Hello and welcome, Community League people.
Uh-oh.
Hello.
Hello. My name is Nora Bagoria. I'm with the Edmonton Federation of Community Leagues. And I'm pleased to present today that we've got our preferred legal team, RMRF, which is Reynolds, Mirth, Richards and Farmer, which is who the EFCL uses. And they're one of our corporate sponsors. And they're here today with some of their team that I will introduce to you to offer this wills and estate planning just for a benefit to our hardworking volunteers out there. So we're really excited. We've got a lot of people registered, got over 80. So it's going to be interesting. That's one of the reasons why we had sent out that sort of pre-event survey of some of the questions and topics that you wanted to go through specifically. And thank you to those people that filled that out. We'll be covering that as well. I'm just going to make sure I give everybody a minute or two. Make sure that everybody's in, because we've got a few more people sort of joining the queue.
Okay, thanks. Is there anything else you want to look at?
Maybe that one over there.
So if anybody doesn't have their microphone muted, if you can mute it unless you're speaking, that would be great, because then it cuts down on background noise. And feel welcome to have your video on if you like. It's always nice to see familiar faces and friends. And I still have a few more joining. And I'm sad to see that none of you are out on your back deck. It's such a beautiful day out. We'll have to have you inside for this lunch and learn. And I think we're almost got everybody from the waiting room in. And maybe I can get Marissa or Stephanie. So I've got two of my colleagues here today. So Marissa McIsaac and Stephanie Kovac, they're helping me. So they're also from the EFCL and just interested in the topic. Maybe they can just keep an eye on the waiting room and make sure everybody else gets in. I'm going to go ahead and start. So once again, my name is Nora Bagori. I'm from the Edmonton Federation of Community Leagues. I'm super happy to welcome you all and to welcome our partners, which is some lawyers and staff from the partners Reynolds, Mirth, Richards and Farmer, RMRF, which is our preferred suppliers, and our lawyers at EFCL that we use, and are always very, very supportive and have been partnering with us and helping community leagues and the EFCL for many, many years already. So I'm just going to let you know a little bit about your presenters. So we've got Shelley Chamischuk. She's an Oliver resident. She's a partner at Reynolds, Mirth, Richards and Farmer, and she's the team lead of the firm's wills, estates and trust team. Her practice focuses on corporate commercial matters, business and succession planning, estate planning, including wills, enduring powers of attorney, personal directives, family trust, and estate administration. She's recognized by the best lawyers in Canada in the area of trust and estates. And Shelley is volunteering here today, so thank you so much, Shelley. And there's also Emma Banfield. She's a Strathcona resident and an associate at Reynolds, Mirth, Richards and Farmer. I'm going to say RMRF from now on. And her growing practice includes a focus on comprehensive estate planning and estate administration. She brings creativity and depth to her legal practice. She's helped in no small part by her pre-law career as a professional violinist. Very cool. So welcome, Shelley and Emma. Also, one of the team members from RMRF that's here today is Christine DeWitt, and she has been, there she is, she waved. And she's helped me organize this today, and it was kind of an idea for her and I to do this. So we're so grateful for Shelley and Emma for joining us. So I'm just going to then turn it over to Christine, Shelley, or Emma, our presenters, and let them tell you a little bit about what the agenda is for today and how this session is going to run. Because as I mentioned, there is a lot of people on the call today. We've got more than 50. So go ahead.
Thanks, everyone. Thanks for joining us this afternoon. Emma and I are happy to be here. We just wanted to start with just a summary of what we're going to be talking about this afternoon. So I hope everybody can see the shared screen and see our presentation. So today's presentation, we're going to just do a short introduction, which we've had. We're going to do then some background and basics of estate planning. We're going to take some commonly asked questions or survey questions, and then we're going to do a Q&A. So those are questions from you that weren't part of the survey questions, that didn't hit the top 3 or 4 survey questions. We'll take some Q&A questions that you pose to us throughout this presentation, and we'll try and get to as many of those as we can. Nora did a great job in introducing me and Emma, so I think you know who we are and what we do, so we'll just get right into it. So we wanted to start with talking about the importance of estate planning. So most people understand that it's important to have a will, and that a will is a document that speaks from the date of death. So a will becomes effective or enforceable from the date of death forward. People tend not to think about what happens before I die, but if I need some help with decision making. So in terms of finances, if I need, if you need some help with your finances, who has the authority to help you, and what gives them that authority? And what if you need some help making personal decisions? Perhaps you're in the hospital, you've had an operation, you're not conscious, or you've been in an accident and you're not conscious. Who's going to make personal decisions for you? Who's going to talk to your doctors? Who's going to be able to give them instructions? So that's what we're going to be talking about today. The importance of planning during illness or incapacity, and planning for after death. So think about it this way: if your spouse or your parent, or a parent of yours, or a child was in a serious accident, who would have the authority to deal with their personal decisions and their finances? So who would be able to have the authority to pay their mortgage and talk with the bank about paying the mortgage? Who would have the ability to apply for disability insurance or talk to an insurance company about those matters? What about paying utilities and property taxes or income taxes? And who would look after any dependents that you would have if you weren't able to do that yourself? And the problem is that when you were asked what authority you have to step in and help somebody, you have to have some documents in place to prove that authority. It used to be that spouses used to be able to take care of each other, call up TELUS or the utility company if an account was in their spouse's name, and just deal with that. And that's just not the case anymore. So we do need to have these documents in place that will help manage somebody's estates and accounts if something happens to them. So we're just going to go through some backgrounds and basics on these documents. And the first document we're going to talk about is an enduring power of attorney. So this is where you appoint a person who we call an attorney, but they're not a lawyer. They can be a lawyer, but they're typically just a regular person. And it's going to be the person who's going to deal with financial matters if you can't deal with financial matters on your own because you've lost mental capacity to do that. There's 2 types of enduring powers of attorney. The first type is a springing enduring power of attorney, and that's an enduring power of attorney that comes into effect in the future. So you sign it today, you name people to be your attorneys to make financial decisions for you if you're unable to because you've lost mental capacity, but it's not going to take effect until that has happened. You've actually lost mental capacity. The other type of enduring power of attorney that we commonly use is an immediate enduring power of attorney. And this is a power of attorney that comes into place immediately upon signing that document. And we use it when we're trying to look after, for example, our parents, elderly people who you're already starting to step into their shoes in terms of taking them to the bank or going to the bank for them and doing some of their financial transactions. If they sign an enduring power of attorney that takes effect immediately, you can do that without them having lost mental capacity. It will continue. If they lose mental capacity, you'll be able to continue to be their attorney and make those financial decisions for them. But it's important. The important difference is that it starts immediately, and there's no requirement for them to go through the process of having been declared to have lost mental capacity to make financial decisions for themselves. And so it's important that you appoint people that you trust to handle your finances, because they can step into your shoes and do anything of a financial nature that you can do yourself. An enduring power of attorney usually deals with a few different powers. In addition to a general power of being able to do anything that you can do yourself financially, it's important that if you have dependents, such as a spouse or children, that you specifically indicate in your enduring power of attorney that your attorney is able to use your funds to support your spouse, your children, or any other dependents that you have, because without that, your money can only be used for yourself, to support yourself, and your attorney is not permitted by law to use your money to support others. It is also important that your power of attorney specifically deal with any land that you own. So it needs to give your attorney the power to sell or rent or mortgage land. Otherwise, your attorney will not be able to do that. So land is kind of a special asset that we have special powers in an enduring power of attorney to allow the attorney to specifically deal with land. Now, personal directive. So this is a document where you name somebody who's called an agent to make personal decisions for yourself and make healthcare decisions. So this document will take effect when you lose mental capacity. And so the law says that if you have the mental capacity to make a personal decision for yourself, then that's the starting point. You make that personal decision. But when you've lost mental capacity to make that personal decision, that's when your agent can step in and make that personal decision for you. So who is the best person to appoint to be your agent? It is somebody who knows you the best, who knows what your values and beliefs are, and can step into your shoes and make personal decisions for you. So their mandate is not to make what they think is just the best decision generally. Their mandate is to think about you and what they know of you, about your values and beliefs, and try and make the same decision that you would make for yourself in those circumstances. And so your agent has the power to make all types of personal decisions for you, and that includes where you will live, who can come visit you, what kinds of activities you will participate in. They can speak to your doctor on your behalf. They can attend medical appointments with you and make medical decisions for you. And they can deal with all types of healthcare and medical matters, up to and including making decisions about taking you off artificial respiration and those types of end-of-life decisions. They can also deal with organ donation. So it is helpful if you've had a conversation with your agent about these matters or have given them some type of indication in your personal directive about what you would want to have happen in terms of medical interventions, and whether you would like your organs to be donated if that is possible when you pass away. Those are decisions that are very difficult to make for somebody if you've never had a conversation with them about how they feel about organ donation, for example. So when you're appointing an agent, it's always recommended that you have a conversation with them, let them know that they've been appointed, and have a conversation with them about the types of decisions you would want them to make for you. Just before we go on to the next slide, I did want to mention that you can name more than one person to act together to be co-attorneys or co-agents for you. It doesn't have to just be one person, and you can also name alternates. So you can say that, my spouse will be my agent, and if my spouse is unable to act, then my son will be my agent, for example. Next slide. Yeah. So the alternative. So it's really important that you have these documents in place. Some people overlook them. And I think the best way to convince people that these are important documents is to tell you what happens if you don't have these documents in place. So the alternative, if you don't have an enduring power of attorney or personal directive, is that somebody has to apply to the court to be appointed your guardian and your trustee, and that happens under the Adult Guardianship and Trusteeship Act in Alberta. So it's a court process, a court application where somebody is being appointed to be a supported decision maker, a co-decision maker, or a guardian or trustee for you. And those are just different levels of decision-making powers that they will have with you or for you, depending on what your condition is. So a guardian is somebody who makes personal decisions for you if you can't do that for yourself. And a trustee is a person who makes financial decisions for you if you're unable to do that for yourself. But the drawback are many. The drawbacks are many, in my view. The first is that it costs substantially more to go through a court process to have somebody appointed as a guardian and trustee. You've also lost the power and the ability to choose and appoint the person that you would want to act for you. So somebody has to apply to be your guardian and trustee, and then the court will deal with that application, as opposed to you actually appointing that person and choosing that person in an enduring power of attorney or personal directive. So we have the legal right to make those appointments, and so it's always beneficial if that has been done. One of the other drawbacks is that the person who is the subject of the guardianship or the trusteeship, so if it's you, the public guardian is going to have a representative who comes out and interviews that person to confirm that they don't have mental capacity to make personal decisions for themselves or to make financial decisions for themselves. And that interview can sometimes be difficult, particularly if you're dealing with somebody who is now in the later stages of dementia or Alzheimer's, and it can just be upsetting to have to deal with a stranger who's going to ask a number of personal questions. Some of the other drawbacks, in my view, of a guardianship and trusteeship process is that the court, in their order for trusteeship and for guardianship, will direct whether an accounting needs to be made to the court and what time frames. So that's where you put all of the bank statements and the financial records of the person before a judge, and they review them to make sure that the trustee is making proper financial decisions for the person, and there's a list of personal decisions if you're a guardian, personal decisions that you've made for this person. So it's a review by the court, and every time there's a court process, that means that there's more legal fees. The documents, although they were made to be fairly simple, and the thought was that individuals could do them without retaining a lawyer, many people find them very difficult. to make their way through. Some lawyers find them very difficult as well. So often you're hiring lawyers and accountants to help you with that process to satisfy the court that everything is in order. And it's a court, because you're in the court, those documents become public. And so I think that that's another drawback of going the guardianship or trusteeship route. And I just wanted to be clear that you don't have to apply for both. Somebody might need a trustee, just a trustee to handle financial matters, or just a guardian to handle personal decisions for them. It's not necessarily that you will have somebody be your guardian and your trustee, but you could be in a position where both are needed. And so Emma is going to take us through some aspects of putting a will in place and why that's important.
Thanks, Shelley. So as Shelley said, there's these kind of two groups of documents. So she's covered the enduring power of attorney and personal directive, which are the ones that are in place when you're still alive. And now we're going to move and talk about wills. And that, of course, is the document that governs after you've passed away. So there are two types of wills. There are formal wills and holograph wills. Formal wills are the ones that you typically think of when you think of a will that has, proper witnessing, and you probably have the assistance of a lawyer to draft it up. And it will go through various clauses covering all of your assets and needs. Pardon me? Oh, sorry, I thought someone had a question there. My apologies. And the formal will is governed by various legislative requirements. So it requires two witnesses, those kinds of things. A holograph will is a bit of an outlier. Not every jurisdiction has holograph wills, but in Alberta, they are still legal. Holograph wills are wills that have to be in your own handwriting and signed by you. And those wills are still legal in Alberta. We don't recommend them. You can probably guess why. They tend not to cover everything. So they don't necessarily cover all the elements that you would want to cover off in your will. And they are often difficult to prove because there's no witnesses, there's nothing kind of extra about them. So we don't particularly recommend holograph wills, but they are legal in Alberta. So Shelley was talking about agents and executors under, or pardon me, and she was talking about agents under personal directives and attorneys under enduring powers of attorney. When we're talking about what happens after somebody passes away, we use the umbrella term of personal representative. And the reason we do that is because under various legislation, there are actually different terms, and those are listed here on the slide for you. So when there's a will, the individual is actually called an executor. When there's no will, but somebody steps into the role of administering the estate of the deceased, that person is called an administrator. And when there are trusts involved, then the official name for that role is trustee. I think we've probably had a few reminders, but if you're not muted, please do so unless you're speaking. So talking generally about executors, or sort of using that as an umbrella term for the person who's administering a person's will, there are some specific roles, and these come actually from legislation. So an executor is required to perform their duties honestly and in good faith. They are required to follow the deceased's intentions, and obviously, those intentions as set out in a will, so they can't deviate from the will without justification and justifying that decision. They are also required to act with the care, diligence, and skill that a person of ordinary prudence would exercise in similar circumstances where a fiduciary relationship exists. So that's language that comes right out of the legislation. Many of you will have come across fiduciary relationships in other contexts, but basically it's a relationship of trust. So the kind of relationship that you would see between a lawyer and their client, or between a doctor and patient. And it requires the fiduciary to act in the best interests of the other person instead of in their own best interests. So an executor in an estate has to put the interests of the estate ahead of their own interests. The executor is also required to distribute the estate as soon as practicable. So they can't hold on to assets, you know, for 10, 15 years in the hopes that the market will improve, or, you know, because they're waiting for something else. They have to do it really as soon as it makes sense to do so. As I mentioned previously, an executor also has a role as a trustee. So when they're dealing with the assets of the estate and holding those in trust for the estate, then their work is governed by the Trustee Act in Alberta. And as it says on the slide, professionals are held to a higher standard. So when we talk about the care, diligence, and skill that a person of ordinary prudence would exercise, there's a slightly higher standard if you have an additional professional designation. So for example, if you're an accountant and you're acting in the role of an executor, you are expected to exercise the, you know, skill and diligence of an accountant, not simply someone who stepped into that role. So professionals are expected to take into account their skills and professional knowledge when exercising their roles as an executor. So turning to some of the more specific obligations of an executor, they are responsible for funeral arrangements for the deceased. They're responsible to look at the estate of the asset of the deceased and identify the assets and the debts. So when they're looking at assets, they're going to be looking at land, they're going to be looking at bank accounts, they're going to be looking at personal items, and they're also responsible to make sure that they're aware of any debts that were owed by the deceased. So that could be things like taxes, property taxes and income taxes. It could be outstanding credit card bills or utility bills. It could be mortgage payments. It could be all of those kinds of things. They need to make sure that they know what's out there that is owed by the deceased. And then what they do is they transfer those assets into the name of the estate, so that because the person who they used to belong to isn't around anymore. So it's their responsibility to transfer assets into the name of the estate and then to start dealing with them. One of the things that can be a bit of a challenge is making sure that you know what all the assets are. So some people will hide things away. Some people have assets that they just kind of didn't mention to anybody, or maybe even that they forgot about. So maybe they opened a bank account many years ago and they just kind of forgot about it. So sometimes the person who's acting in the role of the executor also has to play the detective a little bit to see if they can make sure that they have a full accounting of all of the assets of the estate. So checking things like safety deposit boxes, going through people's documentation to make sure that they capture all the bank accounts and all the property, those kinds of things. So as the testator, as the person who's going to be drafting up a will, one of the best things that you can do is write up a list of your assets to help the people who are going to be taking care of your estate. If you think that you might be acting in the role of an executor for, you know, a parent or a sibling or friend, and they've made you aware of that, one of the things that you can do is ask them to write up a list of their assets so that it makes your job a little bit easier when you step into that role. The executor is also responsible for the control and maintenance of assets. So for example, if the deceased owned land or a home or something, for a second home, they're responsible for making sure that that property is kept up. So they might need to seek the services of a property management firm or something like that. They can't let you know, the power get turned off because that might cause the pipes to freeze. So they're responsible to make sure that the assets are maintained. And moving to the next slide, executors are also supposed to look at the distribution instructions in the will and to carry out those instructions. So if there are specific bequests to individuals, so for example, $5,000 to my niece, you know, it's their job to take care of that. If things are supposed to be divided a certain way, that's the executor's job to make sure a third goes here and 2/3 goes over there, those kinds of things. Executors are also responsible to report an account to beneficiaries. So anyone who's had any experience with this before will know that it's unusual for an estate to get wrapped up in a few weeks, for example. And it will often take years to get land sold, to get all the taxes filed, all those kinds of things. And so over that period of time, the executor has a responsibility to account to beneficiaries for what's going on. So where monies are going, what steps have been taken, what's expected to happen, those kinds of things. As it says on the slide, executors are also responsible to deal with taxes, because as we know, there are two things that are certain in life, and taxes are one of them. So your executor is responsible for filing your final tax return. They're also responsible to make sure that they deal with any trust returns, and they also have to get that CRA clearance certificate in order to wrap up the estate. They're also will step into the role of the deceased if there's any litigation or conflict ongoing, and if the beneficiaries can't agree, or if they are fighting with each other and there's litigation involved, then the executor is the one who directs or gives instructions in the interests of the estate.
So I think, Emma, that takes us to the next part, which was the top survey questions. So as everyone knows, Nora sent out a survey so that we could know what to focus on for this section. And these were the top questions. So they're just all listed here, and then we have a slide or two for each of them. So, so we'll dive right into this. I'll pop to the next question.
So I'm going to turn this one back over to Shelley, I think, is going to talk about this one.
You're muted, Shelley, sorry. Classic video call.
Sorry. I was trying to be good and not make noise. Okay, so this question is mine. Do I need to have an executor, and can I have more than one? So one of the most important things that your will does is appoint an executor, and you can have one person act as your executor, or more than one person. They can act together as your executors, and it's a little bit of a balance, because there's some practicalities of having more than one person act, and having to have more than one person sign documents for the bank, etc. if you have more than one executor. But on the other hand, being an executor is a big job. My executor clients are not always very eager to raise their hand a second time to be an executor, just because it is a big job. And so it can be helpful to have another person to share those duties with, and to perform those duties together. And in a lot of families where after mom and dad are gone, if for example, if there's two children, a lot of parents would say, well, my two children get along, they would make good decisions together, they're both going to be the beneficiaries of my estate, so I think they should share in the work of settling my estate. So parents might appoint both of their children to act together. What's important is that if you have more than one person acting, that they get along and they can make good decisions together. You need to be honest about whether they can get along, and if they don't get along, then don't appoint those people to act together, because that's kind of a recipe for ending up in disputes and in the court process. And so who do people typically look to be an executor? Often it's family members. So if you're married, a spouse or partner, if you have adult children, then people will often choose their children, if that makes sense. But it doesn't have to be. There's no rules about who can or cannot be your executor. So if you're looking outside of family, it can be a friend, it can be a professional like an accountant, a financial advisor, a lawyer, or there are trust companies who are corporate trustees, who are professional trustees that can do that job. And those trust companies typically are appointed where there's a very complicated estate. Maybe there's a business that might need to be run if somebody were to pass away, or there are beneficiaries in the estate who aren't going to get along, and so they know that it's going to be a tough go, and there's going to be disputes. Sometimes people will just hop to appointing a corporate trustee to act for them. And so I just wanted to mention what happens if you don't have a trustee. So let's say you are, sorry, an executor. So you've named a couple executors, they've all predeceased you. So now you're left without an executor. So there are rules in our Estate Administration Act that talk about who has the best right to apply to be an executor if there has not been one appointed or one cannot act in the will. And it would be the people that you would typically guess would be the people with the best right to apply. So if you're married, it would be your spouse. If you're living common law, it would be your common law partner. It would be adult children who live in Alberta, then adult children who live outside of Alberta, and so on down the list until you find somebody who has who can has the right skill set to be the executor and will agree to do the job.
So our second question has to do with what assets are governed by a will. This is a good question because there are a lot of things that are governed by a will, but there are a few things that don't pass or are not governed by the will. So property that is specifically designated in the will be governed by that. So if you've given $5,000 to your niece, then the will govern that. When there's property that is only in the deceased's name, so if the deceased owned a home by themselves or bank accounts that are only in their name, those kinds of things, that will be governed by the will. And then assets that don't have a designated beneficiary. So as many of you know, there's some of them listed at the bottom of the slide, certain assets you can designate a beneficiary. If you don't designate a beneficiary, then again, that will be governed under the will. And wills generally have what are called residual beneficiaries. So those are the people who get whatever's left over. And so where nothing is specifically named in the will and it just forms part of the deceased's property, then that forms part of the residue of the estate and will be distributed to those residual beneficiaries. There are certain assets that don't pass under a will. So any asset that is held jointly, so most couples hold their property jointly, so the home that they live in is jointly owned, which means each of them owns 100% of the land, and if one of them passes away, the other one still owns 100%, and so that doesn't pass under the will. There's also joint bank accounts, and it's the same thing. It's the same idea that each of them owns 100%, and if one of them passes away, then the other one still has everything, so it's not governed by the will. The other assets that typically pass outside a will are those with designated beneficiaries. So the examples listed here are the life insurance, RRSPs, TFSAs, and pensions. And for most of those, you can designate someone as a beneficiary. And so that will pass outside of the will and it won't form part of the residue of the estate.
And the last question is mine. It's what happens if I die without a will? So if you die without a will, then there is a list again in our legislation in the Administration of Estates Act that indicates who has the best right to apply to be your administrator. And it's the same list that I had just kind of recited. So if you have a spouse, it's your spouse or your common law partner. If you have adult children, it's your adult children, preference given to children who live in Alberta as opposed to children who live outside of the jurisdiction of the province of Alberta. If you die, then grandchildren. So if you do not have a spouse, children or grandchildren, then your parents, if they're alive, have the next right to apply. If there's no parents, then it goes to brothers and sisters and on like that. So typically somebody in that list will step in. If you have, so for example, if you have 3 children, all 3 of them have the right to apply if all 3 of them live in Alberta. And so they can all apply together, or they can decide who of those 3 children will apply to be the administrator of the estate. So then what happens with your estate if you don't have a will? So it depends on what your family situation is. If you have a spouse or a common law partner, If your children are all children of that spouse or partner, then your spouse will get all of your estate. If you have a spouse and children from a different relationship than with your spouse, then there is a scheme where the spouse would receive a preferential share, which is currently $150,000 or 50% of the estate, whichever is greater. And then the rest of the estate would be divided equally among all of your children. If you die without spouse and children, then your estate is left to the your grandchildren. Again, it's like your grandchildren if you have grandchildren. If you don't have grandchildren, it goes up to your parents. If you don't have parents, it goes to your brothers and sisters. If one of your siblings has passed away, then their children would step into their shoes and take their share. So there's a huge table that we have that sets out who has the best right to receive part of your estate. So a lot of people are worried that they think that if they die without a will, that their estate would just go to the government, and that's not the case. The government is the ultimate beneficiary, but that's only when no other what's called next of kin can be identified. So that next of kin would include cousins and other more distant family members.
Great. So that brings us to the end of the top questions from the survey. Now, it says live Q&A, but with lawyers, there always has to be an asterisk. No, because when the survey was sent out, there were additional questions that came in. We thought it would be great to sort of kick off the live Q&A with some questions that have already been received, because why not? So we're going to be using the chat function to submit questions. So if you do have a question that you want to put in the queue, put it in the chat, and Nora and I guess the whole team at EFCL is monitoring the chat to do that. But we're going to start with some of the questions that we've already received. So I'm going to ask them, and there's a lot. I recognize it's already 12:43. This is, as you can imagine, a topic that we could talk for hours and hours about, so we'll do our best to get through as much as we can. The first question is this, maybe I'll direct it to you, Emma. What is the simplest way to update an existing will?
Thanks, Christine. So if you already have a will and you have a really small change, so for example, you just need to swap out an executor or something like that, then there's the option to do what's called a codicil, which is basically like a little addendum that goes kind of attached to your will. And that's a really great way to do tiny little changes, like not big changes, not overhauls, but just small ones. The other way that I would suggest is if you have already made a will, so for example, in our offices, making small changes to existing wills is pretty straightforward because we keep copies of them, so we already have them. So making small changes can be, doesn't take us very long, and can be quite simple. So when we're talking about relatively small, simple changes, those are kind of two of the best options I would think to update an existing will.
Great, thank you. The next question is, where is the best place to get a will made, and are will kits any good?
So I have decided opinions on will kits. My suggestion, of course, recognizing who I am and what my job is, but my suggestion would be to go see a lawyer. My concern with will kits is that they don't necessarily cover everything, and if you make a will and you don't address something or you leave something out, then sometimes there's a couple possibilities. One is it's as good as having no will, in which case it was a waste of your time. And the other possibility is it will lead to confusion and disagreement. And when that happens, what often results is litigation. And as Shelley has already addressed earlier in the presentation, as soon as you end up in the court system, it's going to cost money, it's going to take time, and it will lead to strife within families. So having a good will that covers all the bases and is clear, that reflects the most current law in your jurisdiction, I really think that that's the best answer. So my recommendation would be to see a lawyer.
Great, thank you.
I'd just like to add to that is that I haven't spent a lot of time looking through various will kits, but when I look at wills that people have done using a will kit, it seems to me that the instructions to filling out the will are likely not as clear as they could be, because when I look at wills that have been done using a kit, it's clear to me that the person who made the will did not complete the will properly. So they didn't understand where to put certain information. They didn't appoint an executor at all, or properly. That's one of the first comments I would make about will kits. So they're often drafted not for a specific jurisdiction, so not just for the province of Alberta, but there are like Canadian will kits out there that and are in each jurisdiction has their own laws and their own rules about wills. So that makes it a very difficult task to draft out, one good will template that will work in every jurisdiction. And I think the other thing is that as lawyers, we're trained to choose our words very carefully, and we try and write a will so that it is as clear as possible, and there's only one interpretation of the will. So to have somebody who, when you're trying to do that on your own, that can be very difficult. And my experience is that it's often the case that the language that the person has used to write the will is not as precise as it could be, so it's open to more than one interpretation, and as Emma says, that just leads to disputes and time in court if the beneficiaries can't work it out amongst themselves.
Great, thank you. Thanks for that, Shelley. The next question is, what considerations are important for choosing legal guardians for children?
So one of the things that you can do in your will is appoint guardians for your children. So in terms of considerations, you're going to want to think about your kids, right? And where they live and what's important to them. So you probably are going to want someone who would raise your children in a way that you would agree with. You're probably going to be looking for somebody who could keep them where they are, or provide them with the stability that kids who've just lost their parents are going to need. One thing to keep in mind is in families where the parents aren't together, even if one has custody over the child, the other parent is still a presumed guardian. So that's just a consideration to think about when you're thinking about guardians for minor children. But one of the nice things about the will is that that's a question that you can think about before it comes up, and again, have in place immediately if something happens to you, and you don't have to deal with the public guardian and trustee, and you don't have to deal with the court, and that can provide some stability and continuity for kids when they're dealing with the loss of a parent.
Great, thanks. We just have a couple more. I think these are probably broad enough that we do want to get to them. So the first one is, what are the tax implications for inheritance?
So I'm going to let Shelley talk about that one, because I know that's an area she's well versed in.
So what's important to know is that in Alberta, we don't have estate taxes or probate taxes as they do in some other provinces, such as Ontario and British Columbia. So therefore, our estate planning is not driven by trying to ensure that your estate has the least number of assets and the least value in it. In addition, in Canada, there is no general estate tax as there are in other countries. So when you pass away, you are deemed by CRA to have sold all of your assets on the day that you pass away, and then the tax consequences flow from that. So for example, if you have an investment account with a stock portfolio, and you've had it for a long time, let's say when you invested the stocks were worth, $10 altogether, and when you die, they're worth $100,000, then you will be deemed to have sold that on the day that you died, and that capital gains will be paid on the difference of the value from when you purchased it, the cost base, and when you passed away. So that's how the tax implications work. But it's important to know that there's not a specific estate tax or probate tax, and those are terms that you will hear. And if you're online and you're reading information from different jurisdictions, it's important to know what jurisdiction they're writing from, because the tax implications that they're talking about may not apply in Alberta. Alberta is a jurisdiction that has one of the most favorable tax regimes when it comes to estates. So again, not only does it affect the taxes that are owing, but also the way that we plan. Always good to keep that in mind when you're reading something that's talking about different tips for planning, because those tips may not be important if your estate is in Alberta.
Great. That's the end of our list. So I'm going to pass it over to you, Nora.
Okay, great. Thanks. I'm going to actually put a copy of all the questions that we received in the chat right now, so you can see them. So Shelley and Emma, you can sort of see all the questions that came through while you guys were doing your presentations. Thank you so much for that. It was a lot of information. Some of the questions we might have touched on a little bit, some of the answers, but if not, I was wondering if maybe one of you could maybe tackle the first couple of questions, and then maybe the other one could answer a few of them in the chat itself if we don't get to them, because we've only got about 8 minutes left.
Okay, sure.
Yeah.
So the first question that they have is, and this is what everybody was asking me earlier, was just whether or not these slides will be sent out, and I'll be sending out the slides in a post-event email afterwards. So after that, then the next question, Shelley, is if your utilities are in both names, do you need backup documents to pay bills?
Typically, my experience is that if the utility bills are in both names, that you as the survivor of the two people will have authority and access to deal with that account. It's when the account is solely in the name of the deceased person that it can be a problem. And sorry, my screen just slipped, but I know that there was a question about the second question there about personal directives. Is your spouse the default agent? No, that's the problem. There is no default agent. Outside of doing a personal directive, nobody has the automatic right to make personal decisions for you or financial decisions for you. That's why it's so important to put enduring powers of attorney and personal directives in place. A lot of people assume that if they have a spouse, their spouse would have the authority to make those decisions for them, and that's just not the case. So those documents become really important to have in place, and really to make it easy for the people who are going to step in and help you to be able to do that and do their job. So my view on estate planning is that, some of it is to protect yourself, for example, to make sure that your estate goes where you want it to go at the end, but also to make it easier on your family, on the people who are going to be having to kind of pick up the pieces and move things along if something happens to you.
Great. And then another question is how is one deemed to have a loss of mental capacity? Has that been covered?
No, Emma, do you want to take that?
Sure, I can talk about that one. So usually what we expect is that you would have your mental capacity evaluated. Usually that's going to be done by medical professionals. And when you are drafting your enduring power of attorney and your personal directive, you can kind of choose what the conditions are. So our kind of default is to have 2 medical professionals declare in writing that you've lost your mental capacity. So the process for that is usually people start with their family doctor, and doctors have a series of questions that they can go through to assess your mental capacity. And then often your family doctor can refer you to a second person, but it doesn't have to be your family doctor. It could be any doctor. And it's important to remember that there's different types of capacity. So legal capacity can be different from, you know, other types of capacity. And so when we're thinking about what you can do, that's what your doctor is assessing for you, is what your capacity is and whether you're able to make those types of decisions.
Great. One of the next questions was with respect to if that asset list you were talking about, the list of all the assets, needs to be cited in the will, and should the executors live in the same location in order to execute the will effectively?
So the list of assets doesn't need to be cited in the will. It certainly can be. There's no reason why it can't be. Often what we do is we tell people that they can make that list or a memorandum and put it what we call behind the will, and we'll often reference a memorandum that sits behind the will in the actual will document itself. And that way, if the list isn't up to date, then it's okay. So in many ways, it's actually better to kind of have that asset list sitting behind the will and kind of make that a living document that your executor can refer to when they're carrying out your wishes, than it is to kind of name everything specifically in the will, because then the executor is bound to the will, and if those assets aren't there when the will comes into effect, that can cause problems. So to go back to the question, the asset list doesn't need to be cited in the will, but we often refer to a memorandum that sits behind the will. Regarding whether executors should live in the same location in order to fulfill their roles effectively, it's certainly simpler. There's a reason why the legislation prefers adult children living in the jurisdiction to adult children who don't live in the jurisdiction, and it's just a matter of practicalities. If you have to choose between your son who lives next door and your daughter who lives in Portugal, it's certainly going to be easier for the kid who lives in town to deal with banks, register things with land titles, talk to lawyers, all those kinds of things. Just from a practical perspective, it's not a requirement under the legislation. It's not like they'll be disqualified. But if you're trying to choose between two people and one of them lives locally and one of them lives out of province, probably better to go with the person who lives locally, and then you can always put the other person behind that person as an alternate if you really think they're a good option.
Nora, I'm just going to jump in here because I see that we only have a couple of minutes left, and I just noticed that there was one kind of general question about when is a good time to make a will, and I just wanted to hit that point to say that, you know, in my view, I think everybody should have a will, whether you have a lot of assets or a few assets, or whether you're married or not married, have children or don't have children, because if you don't have a will, then it's very difficult for those first steps to be taken and for somebody to step in and deal with whatever you have. So my advice to everybody in my view is that everybody needs to have a will. If you're over 18, you should have a will, at least appoint somebody to act for you as your executor. And as you accumulate assets, that will govern those assets. And it just makes it much easier in what is already going to be a very difficult time for your family. And if you think you're going to be in the position where people are going to look to you to sort out an estate, and you know that person doesn't have a will, I would encourage you to encourage them to put a will in place to make things easier for you.
You know, Shelley, that actually leads in really well to the last slide, this little call to action slide. That was sort of a nice button on top, so I think it might be good to move to that.
And it is at 1 o'clock now, so I just wanted to take a minute to thank everybody, especially you, Shelley and Emma, for your expertise and volunteering today to answer a lot of these questions, and you, Christine, for helping us get this together. We are going to send out a post-event email. It will have a copy of the slides, and it will have a recording link, so you guys can look through this later. If we have an opportunity to answer a few more of the questions, we will. And there's also going to be a post-event survey in there, so you can just kind of give us some ideas as to how you thought about the session, and future sessions and things like that. So if you are able to look for that email and respond to that post-event survey, we would really, really appreciate it. Anything else you want to say, Shelley or Emma?
Just thank you everybody for attending. It's great to have the opportunity to speak with you. We hope to be able to do this perhaps in person down the road on other topics, but thank you very much for joining Emma and I today.
Great. Thanks for the hand clap, Tony. Okay, well, I'm going to let you guys all go. I'll leave the meeting now and end it for everybody, and then we will connect later. Thank you.
Thanks, everyone.
Thank you.